Except for the attorneys and the fee. How much was it? The fee, I think, like, further cost like 17.
So that's
Something
Swiss
sort of was,
prices.
yeah, it was something like that. For the attorneys, I don't know. No, I don't know.
That sounds like
How long were you there for? I think I left was, I was in, it was midnight.
Was it more stable in Geneva or was it
No, I
also
still
far out?
only stayed,
just at that area.
Oh, in this area.
Yeah, yeah.
Ah, okay.
literally just walked right there with two managers go up. Just like 10 minutes.
I did like roughly like 1 hour, so I was like, wow. That's why I didn't like, but next time I'll.
Yeah, yeah. But I think they said that usually after Tuesday,
They all.
go for a drink. For all, like, for all, we're going to get more.
And he said that it's fine.
Thank you, that's really, thank you.
Yeah, yeah. Okay, you don't have to dive.
Hi, good morning, everybody. Good afternoon, rather. Hope you're doing great. I do apologize for having, revolutionized your time schedule on a Friday. Hope your semester is smooth sailing so far. So I suggest we follow up on what we said 2 days ago. Maybe before turning to how to coordinate potentially overlapping jurisdictions, a quick word about why do defendants tend to challenge jurisdiction every time they have an opportunity to challenge jurisdiction in international cases. This may be true also in domestic cases, but I have more familiarity with international cases based on my experience. And this is something we're going to realize by reading the ECJ judgments and the stories that they have to recount. Defendants do challenge jurisdiction. Why this is so? Number one, to make claimants' life harder. That's part of a strategy in order to delay proceedings, to increase costs for claimants, to push claimants, to fatigue claimants, to delay. And to push them sometimes to withdraw their complaint or to induce a settlement that might be more favorable for defendants. Let's not forget, this is a point that I think I repeatedly mentioned, especially during class number 1 and number 2, most of cross-border litigations ultimately results in the parties settling the case, and so the reason why the defendants are so desperate to challenge or contest jurisdiction is because who wins the battle over jurisdiction may be in a significantly more favorable position when it comes to negotiating the terms of an agreement. The second reason why defendants tend to challenge jurisdiction whenever they have an opportunity to do so is to neutralize any unfair under their perspective benefit claimant might gain from choosing forum. Ultimately, if the claimant has potentially the choice between two fora, one is more favorable for claimant, chances are the one that is more favorable for claimant is also more disadvantageous for the defendant, and the other way around. And so the defendant, in that it challenges the jurisdiction of the court chosen unilaterally through forum shopping, through a race to the forum by the claimant, is also a strategy to counter, to push back, and to counter an advantage, to prevent, to try to prevent the claimant from reaping the benefit out of the choice of the court. Sometimes the idea is to make sure that the dispute is heard in a country other than the one chosen by the claimant in order to make things harder for claimant when it comes to enforcement. The litigant sometimes may prefer to litigate in a for them distant, in a forum where they do not have assets. They already think at enforcement stage, they know they have a little chance of succeeding as to the merits, but what they want to do, that's also part of a strategy, is to make sure that the judge who is adjudicating the disputes is a judge of a country where they do not have assets. So in order for that judgment to be implemented, the claimant, judgment, creditor will have to undergo another proceedings in a country where they have assets, cross-border enforcement, which may present a set of challenges. Now, moving to how to coordinate jurisdiction. So the situation we have in mind is the one where, based on the jurisdiction selecting rules, two countries and the courts of two countries have jurisdiction. And now, how do we go about, and how do countries go about trying to minimize the risk of overlapping jurisdiction, the risk of actual conflict of jurisdiction? We may think about two models. Model number one is between two courts having prima facie jurisdiction based on a connecting factor that is relevant, based on the applicable jurisdiction rule. Between those two courts, prior in time controls. Prior in time is essentially the court which is first filed has a right to entertain the dispute, and the court which is second filed, even if the court second filed also has jurisdiction based on a relevant applicable rule on jurisdiction, the court second filed has an obligation to stay the proceedings, to refrain from adjudicating on the merits. That's essentially the prior in time rule that favors the first filed court. I'm going to use those two simple expressions, first filed court or court first filed, and second filed court or court second filed. This is basically the system that operates in the context of Brussels I regulation and Lugano Convention, which are applicable. We're going to study closely the scope of application in civil and commercial matters, including family matters. This is the preferred system in Europe. Now, what are the advantages if it is the preferred system in Europe in contractual, in civil and commercial matters, not necessarily in family litigation? This means that the system has some advantages. Otherwise, why would the European institutions and legislative bodies choose such a system? It is clear for the courts, relatively easy to handle for the courts themselves. In other words, the court first filed has to make sure they have jurisdiction based on a jurisdiction selecting rule. If they are satisfied they do have jurisdiction based on typically domicile of the defendant, that they have no choice, they have to entertain jurisdiction. Court second filed, if they are satisfied, we are second filed, even if we have jurisdiction, they just have to refrain from adjudicating without having to engage in a long inquiry about which is the most convenient form with respect to the specifics of that particular case. This is also relatively easy for a prospective claimant. You know, a prospective claimant knows that if really that litigant is going to be the first one to file a proceedings, then the court having jurisdiction seized by that litigant will have to exercise jurisdiction. And so, you know, this gives some comfort. There's no risk. There's less risk of filing a proceedings only to hear the court is going to say, I'm sorry, we have to dismiss the case because we don't have a jurisdiction. Actual parallel proceedings are less frequent. Why? Because it is less likely that one of the litigants, typically the defendant with respect to proceedings number one, will file a counter proceeding before another court. So it is less likely that a court of competing concurrent jurisdiction will actually be filed if I sue you before court one. And you're not happy with being sued before court one because you think court one is going to favor me, okay? And you're tempted to file a proceedings, potentially declaratory proceedings before a court two. But if you know that court two will have no choice but dismiss the proceedings because court two is going to be second filed, then chances are you're not going to file the second proceedings. Because to file another proceeding, that costs money. You need to have representatives. You need to have attorneys, not just before court one, but also before court two. And so if you have little chance of, or you have virtually no chance of having court two concluding we are going to hear the case, we have jurisdiction, why should you be bothered initiating proceedings before court two? Sometimes, but these are fortunately rare occurrences, it's not easy to determine what is the course first filed. I was once involved in a litigation, divorce litigation. Husband was Swiss. Husband, I think this is a case I already told our friend David from Colombia about, divorce. So the husband was Swiss. Husband filed for divorce in Switzerland before the court in Neuchâtel. The wife was Colombian, although she predominantly lived in Florida, and she filed a divorce in Florida. So actually she filed first a divorce petition in Florida, then husband filed a divorce petition in Switzerland, but the first petition by wife in Florida was irregular, and so she needed to file an amended petition in Florida, which is the reason why the Swiss court said, we are first filed, because the relevant date I had to base myself on to determine which is first filed, which is second filed, is not the date when wife filed the original petition for divorce, but the date when wife filed the amended petition for divorce. And so the Swiss court concluded, this lady, single judge, lower court in Neuchâtel, I am first filed. Now, the Florida court, was also a female judge, single judge in Florida, had to interact with her during a cross-examination, and she reached another conclusion. She said, no, I am first filed because the relevant date is the one of the filing of the original petition, which is an earlier date than when husband filed in Switzerland. But these are really rare occurrences. But this also explains, sometimes the uncertainty one may have. What exactly is the date at which proceedings are pending in the countries? This is the reason why in Europe, if you look at Brussels I regulation, we're going to study closely this provision. I think Article 31 or 32, they try to determine as precisely as possible which is the procedural act, the document filing proceedings, whether sometimes it's when it is filed, sometimes when it is served onto the defendant, in order to avoid the situation of uncertainties. What are the weaknesses of this prior in time rule? That's a relatively blunt, rigid, inflexible approach. The court first filed is not necessarily the most convenient forum based on all circumstances of the case. If you think about case study number 2, China, Australia, I'm going to assume mercantile insurance files first in China. If China and Australia both rely on prior in time, then this means that the Chinese court will have to hear the case, and Barbara Nilsson is precluded from filing the same proceedings before a court in Australia, even if one may contend that in a particular case, Australia has greater connection with the dispute than China, right? Another disadvantage, another drawback of this prior in time rule is that at any point in time, pre-litigation, at any pre-litigation stage, is uncertain which is the court having jurisdiction, because it will ultimately depend on what court is going to be filed first. And before any actual filing, there's no idea, the parties have no idea of what is the court that is going to be filed first. And this encourages the parties to rush to the forum, race to the forum shopping, rather than encourage negotiation and settlement. Keep in mind what we said at the beginning. Litigation should be a last resort measure. Settlement, mediation. Actually, if you look at the legislation, domestic legislation or European legislation on mediation, you get the impression that what the countries and the authorities, the public authorities, really want to encourage is an amicable settlement. And prior in time rule may do exactly the opposite. Rather than encouraging settlement, prior in time encourages one party who might fear that the other party is going to secure a more favorable forum to try to be the first one to race to the forum. Sometimes a forum shopper, right? Forum shopping, there's all sorts of literature about forum shopping. The idea behind the step taken by one potential litigant, I'm going to be the first one to file, is not so much because I want to have an advantage, a competitive advantage over my opponent, but because I want to avoid my opponent to get a competitive advantage over me, right? So behind in the psychology of the litigant who decide to fire first, right? This is a language of a war, of a battle, fire first, is not so much because I really want in bad faith to get a benefit to your detriment, because I want to prevent you from getting a benefit to my detriment. And my only choice is to be the one who filed first. Forum shopping, so the prior in time, is ultimately a system that relies on a unilateral choice of forum by one litigant. The quickest, who is often the wealthiest, the one that may secure best and most expensive legal advice on where to litigate. We may think that in case study number 2, the quickest party may be mercantile insurance that may engage in expenses in order to have a legal opinion on what is the most favorable forum. Keep in mind, sometimes I have been, in my career, requested to identify pros and cons of litigating in before Court 1 or before Court 2. Last year, I had to spend 2 hours in offices of a law firm in Geneva, together with client. It was a lady who wanted to divorce, and she wanted to know where am I likely to be better off in terms of financial consequences of divorce, which is the most favorable between, it was Qatar, where husband and wife have lived long years, or Switzerland. And what she wanted to know is, what are the chances of a Swiss court, if it is filed first, to say, yes, we have jurisdiction? What are the chances of Qatari court concluding we have jurisdiction that filed first? And what also happens, this is also a conversation I had with you, David, a very interesting question you ask. What the natural defendant, typically the party who may really be ordered to pay contractual damages to the other, this is what I call natural defendant. The natural defendant may become technically claimant, not so much because he wants to have justice served, but precisely because they want to delay justice. And so what a natural defendant may decide to do is to start proceedings between two courts having both jurisdictions before the court of the country whose judicial system is less well-functioning, less efficient than the other. This is called sometimes Italian torpedo or Belgian torpedo. This is European terminology. Why Italian? That 20 years ago, there was a famous case, Gasser case. Gasser was a case involving an Austrian company and an Italian company. And the Italian company failed to pay some invoices. And the Italian company filed proceedings before the court in Italy. The Italian company was the natural defendant. The Italian company became the claimant with respect to Italian proceedings. Now, the system has been criticized for allowing some, bad faith litigants to secure a forum not to obtain justice, but to slow down the administration of justice, to fatigue their opponent. And this is an abusive process, but in Brussels I regulation and Lugano Convention, there's no rule that specifically sanctions abusive process. Italian or Belgian torpedo is a mechanism through which a litigant can slow down adjudicating process by filing first before a slow court and preventing the other party, the natural claimant, to obtain a quick administration of justice before a competing court. So all those drawbacks associated with prior in time leads us to talk a little bit about competing system, search for the most convenient forum in the individual case between the courts that have prima facie jurisdiction based on the international rules on jurisdiction. This is sometimes called forum nonconvenience. In common law countries, forum nonconvenience doctrine, we're going to study in detail this doctrine. In India, for example, this doctrine seems to exist. In UK, it originates from Scotland. In Canada, there are also some civil law countries like Panama, like Japan, and civil law jurisdiction like Quebec that are familiar with this doctrine. Brussels I regulation convention reject this doctrine, meaning that the first filed court has to entertain jurisdiction, even if the first filed court thinks there exists more convenient fora in other member states. What are the strengths of this forum nonconvenience doctrine? The forum, the ultimate forum, so the court that will ultimately hear the case is determined by a court and not by a claimant, not by the litigants, based on objective factors, based on connections, based on place of evidence, based on governing law, so the whole bunch of factors that may be factored in, included in the assessment. The assessment is conducted by a court, a supposedly impartial body, rather than by a litigant, the one who runs faster than the other. And this is a system that may promise to be just and fair towards the parties involved and towards the countries involved. As we say, the claim of a country, of the courts of a country to hear the case is more justified the greater the connections the dispute has with that country. And this may discourage forum shopping. The system may encourage the parties with a view to an amicable settlement. So there's less incentive for the litigants, for the parties who have a difference, who disagree, to quickly rush to the forum, which cause the dispute to escalate, and which cause an animosity to also increase. What are the weaknesses? Long and potentially expensive inquiry about best forum, which means that the actual determination of the disputes, the actual adjudication of the disputes might be delayed. Great focus on, so a first significant part of the analysis by the court or courts might be ultimately what is the court that has the, is more position, is best position to administer, to deliver justice in this system. So in some forum nonconvenience cases, when I say forum nonconvenience cases, is cases where forum nonconvenience doctrine have been relied on by the defendant, who said, okay, you might have jurisdiction, Your Honor, but there's an alternative forum that has a greater legitimacy. It's closer, and sometimes the analysis on the part of the court dragged on for 1, 2, 3, 4 years. So compared to prior in time has an advantage in terms of simplicity and in terms of practicality, right? Can be long and expensive because there are a number of factors that the courts might. Second challenge is who is going to decide which is the most convenient forum, right? In a situation where, one litigant files with court 1 and the other files with court 2. Is it for court 1? Is it for court 2 to decide whether court 1 or court 2 have the greatest legitimacy, the greatest chances of delivering justice? If we allow both courts to make that determination, then we may end up having two conflicting determinations. Court 1, the court first file, may think I am the most appropriate forum. And court 2, on its own determination, may think I am the most appropriate forum. So may not be dispositive, actually, unless we determine that one of them has the last word, which is something that happens between the European Union countries in child-related litigation. Think about case study number 4. That's the Swiss French child custody case. Now, there is a convention that is called 1996, Hague Convention on Protecting Our Children, that is enforced both in Switzerland and in France. And this convention allows two courts that have been seized by the litigants to engage in a conversation, to engage in a dialogue. Article 8 and Article 9, very interesting provision within this multilateral instrument. And so the courts of those two countries, Geneva and Paris, they have a common language, French, which make things easier. They may engage in this dialogue, just pick up the phone and discuss. And if after discussion, like they were forming a kind of binational panel, right? They're discussing, each of them presents his own views. Maybe one of them manages to convince the other that, so sometimes it works, sometimes it's not that complicated, for example, for the Swiss court to be persuaded that the French court is better situated, or the other way around. Very interesting mechanism. If an agreement is reached, then it's kind of binational decision on jurisdiction. If an agreement is not reached, then the first filed court has jurisdiction. This is a system that is organized and set up in Hague Convention 1996, as well as in Brussels 2A regulation. Brussels 2A regulation is an important instrument. It's like Brussels 1A regulation in terms of the countries to which it is applicable, but Brussels 1A regulation doesn't apply to family law matters, and Brussels 2A regulation applies to parental responsibility and divorce. What about setting up a binational tribunal ruling on jurisdiction? What if a French-Swiss tribunal determines whether French or Swiss form is most appropriate? This reminds me of a case involving India and Italy. You know, India, the home country of some of our friends who are in attendance here, Italy, my home country, okay? So this is a case that was really interesting to follow. Enrica Lexi. Enrica Lexi is the name of a vessel, Italian flag vessel. Two Marines on board of the vessel, they thought, you know, though that distant boat is pirates, and so they shot. Actually, they were not pirates, they were Indian fishermen. And so the Marines were captured and they were held captive in Italy. And there was a disagreement between the Italian government and the Indian government over criminal jurisdiction, over those Marines, and also over the consequences of that incident. And so they decided, the two countries, through their governments, to submit the dispute to the Permanent Court of Arbitration in The Hague. There was 5 members. You know, you may check who the identity of those 5 members of the panel, right? 5 adjudicators. One was Italian, another was Indian. I think one was appointed then died during the proceedings, so it was, you know, to replace him, it was a relatively long process. Bottom line, the PCA concluded that there's an immunity for those 2 Italian officials, Italian Marines, because they were acting as state officials. But what the PCA also said is Italy has to pay compensation for damages, and the PCA encouraged the 2 countries to reach an agreement as to the amount of damages. Interesting, the reason why I mention this is because one of the key questions was, what is the country that has criminal jurisdiction over the 2 Marines? Italy said, it's us, because they enjoy immunity. And India said, it's us, because they do not enjoy immunity. And so, you know, a higher court where an Indian member and an Italian member was sitting was ultimately entrusted through an agreement between India and Italy with responsibility of determining whether or not immunity applied. Let's now talk about another model on how to coordinate the exercise of jurisdiction. That other model, Model 3, is why shouldn't we permit the parties themselves to choose the competent court? Jurisdiction agreement, choice of forum agreement. Sometimes the term forum selecting clause is used because the jurisdiction agreement is incorporated in a clause which is incorporated in a contract. Think about case study number 5. Would it be possible for the Swiss company and the Indian company to incorporate in the contract? Remember, it's a contract for the supply of luxury watches from Switzerland to India. Would it be possible, permissible, for the 2 companies to incorporate in their contract a choice of forum clause? And if so, should the parties be allowed to, or the parties allowed, but here we were reasoning in terms of policy, right? Like we were legislators. Would it make sense for Switzerland and Indian to allow the parties to choose Swiss court? Probably yes. To choose Italian court? Probably yes. What about choosing a court in Singapore? meaning the court of a country that has no geographical connection. But if the party chooses Singapore, then there's a kind of connection they're establishing. We said private international law, an area of law that is premised on connections. We didn't mention the psychological connection, right? Now, so we may think that precisely because the parties choose Singapore, through that choice, they establish a psychological connection with Singapore. I think we have a question.
I don't need you. I need a microphone.
Right, but I think for those who are listening, I think it's better. Right. Not for you, obviously, not for those who are here, but otherwise they're writing to me saying, we didn't hear the question.
Yeah.
Right.
So my question was, at Model 1 you talked about the Lugano Convention
Right.
and about the Brussels 1.
Right.
Yeah, so isn't that an agreement between the parties about jurisdiction?
Right.
Like between states about jurisdiction?
Right. Interesting. When I talk about jurisdiction agreements, is by the litigants themselves.
Okay, no,
Right.
yeah, okay, by the litigants.
But you're right in saying that when we have a cross-border relationship between private individuals, we have individual parties, private parties, but also we have state parties.
Exactly.
And so, but the jurisdictional agreement, we may write a couple of words so that it's not confusing. What I mean is a agreement between the litigants, the private parties, over the form, over this. I'm sorry. Go ahead.
So my question is about the Enrica Lexi case.
Right.
I wanted to understand Italy's defense. If they claimed sovereign immunity, how could that immunity have extended to like acts which are obviously not in their official, they are outside the scope of their official duties, right? I mean,
Right.
killing fishermen is obviously not within their official.
But at the same time, in an army, when somebody is a military, if they're killing somebody, feeling they might be threatened, they thought they were pirates. They were acting, the conclusion by, I don't know exactly the details of the case. You may quickly check, typically through the assistance of an IA, but I think the conclusion was, I quickly read the relatively long PCA, Permanent Court of Arbitration ruling, and the conclusion was they were acting as state officials. Even if they were on board, Enrica Lexi was not a warship. Right. But, you know, I'd rather not comment about the specifics of that case, right? Especially like as an Indian, I feel, you know, it's legitimately a concern. As an Italian, you know, that's one of the problems in having international litigation. This is precisely the reason why ultimately we had an Indian member and an Italian member in the panel. And we had 3 other members. You may look up for the nationality of 3 other members. But, you know, I think the PCA, I rely on the PCA to have rendered a reasonable judgment. Obviously, as I said, you may continue to think that, you know, India may continue to think that they were right in contending that those 2 gentlemen were not acting as a state official, right? So the litigation and adjudication is necessary to solve a dispute and to make sure the human society may prosper collectively. This does not prevent a litigant, unsuccessful litigant, the losing party, to think that the judgment is wrong. Right? Criticism. I have a lot of colleagues who routinely think that the judgments by the federal tribunal tend to be wrong. Right? That's part of living together in a society. We may discuss endlessly about whether something is more justified than another. That's the beauty of democracy, you know. Disagreement is something that is key to democratic countries, and is key also to the judicial system. And the disagreement between the litigants may not disappear when there's a judgment, right? But being part of a rule of law country is to accept a judgment even if we vigorously disagree with the outcome that has been reached. But you know, if you want to discuss the specifics about the decision, I should study, and we can really discuss. Fine. So, possibility to select a neutral forum. Would it be a good way to do things? Some countries, I think about China, tend to think that a choice of forum, to be justified, has to designate a judge of a country that has a connection, right? The chosen forum has to be the forum or a chosen court, chosen by the parties, have to be a country that already has a connection with. And this is a position of some countries. I try to look up on the internet to know what the position of India is about the specific countries. I spent half an hour. It's not easy. You may think you have the answer, but it's not easy to really identify the position of. The position of, I think, Article 20 of the Indian Code of Civil Procedure 1908 is not clear, is not necessarily adapted to international contracts.
Simple answer is no. So
Right.
in arbitration we allow choice of forum,
Right.
but in litigation we do not allow that.
Right.
We can't ousted a court which has jurisdiction contractually between two parties.
Right, right. So this would mean that probably India would accept to abide by a choice of Swiss forum, at least when it comes to, the watches that had to be delivered in Switzerland. I read a decision where that received different comments by Indian authors, if some of you wanted to somehow intervene.
Do you think allowing parties to choose their own
Sorry, I'm not sure it's going. But
should I stay?
if you can, yes.
Do you think allowing parties to choose their own jurisdiction might play into the difference in bargaining power that the parties might
Right.
have, and then be counterproductive?
Right. Interesting. You want to say something?
No, I was just with respect to the similar thing with respect to forum hopping. Essentially, what he said is absolutely correct. When you reference to the seat, there was a recent decision which came out in a few years back wherein
Right.
even two Indian parties can choose a foreign seat. But with respect to forum,
Right. The scriptures on the part of India. So India allow for the choice of arbitral forum, wherever in the words, and they tend to restrict a choice of judicial forum. I'm not sure if this is justified, right? Especially Singapore International Commercial Court. There's an Indian judge sitting there, and actually happened to supervise. I was the supervisor of the cases, written by a clerk, an Indian student, mid-student, previous generation of mid-student, who happened to be the clerk to this Indian. Anyway, we may have a rather favorable position when it comes to allowing the parties to choose the court of a country having no connection, right? Precisely because it is neutral. Although there's a drawback, admittedly, if the chosen court is sitting in a country having no connections with the parties, then the judgment that will be delivered by the chosen court is likely to have to be enforced in other countries, because if that country has no connection, then the potentially losing party has no assets. And so a chosen forum having no connection with the parties or the dispute, a neutral forum, disadvantage is the judgment has to be recognized and enforced in other countries. Yes, David.
Can we use in that case
Yes, so there's no obstacle. We're going to study the rules in Brussels 1 closely at a later stage, but the there's a favor on the part of the European authorities to allow the parties choice of form regardless of any connections with. And this is also true in a Hague choice of form instrument, 2005. India is not part of that instrument. European Union is part of that instrument. And this instrument says that no connection between the chosen forum and the parties and the dispute is required in order for that choice of forum to be permissible and to be valid. Fairness to individuals, in terms of the advantages, we're relatively fair to both individuals, to both parties, particularly because if we allow them to discuss and to choose themselves the single court before which they will submit any future disputes, if any dispute arises, that's a bilateral choice. We encourage them to make that choice at a time when they understand each other. When you make a contract with somebody, you know, generally you're building on a common project, right? So that's really the appropriate time when you may reach an understanding. Once a dispute arises, then, you know, things are more complicated. An understanding can be harder to reach when a dispute arises. But at a time when this also applies when two spouses, international marriage, get married. At the time when get married, and the time when make a marriage contract, a marital property agreement, this is appropriate time when they are more likely to find an agreement as to where to litigate in future. The beauty of the choice of forum is that this is something that you are unlikely to read in any textbook, but choice of forum encourages good faith, and choice of forum discourages litigation. Why? Because once it is established that the parties really choose that forum and that choice is valid, then in order to try to predict, identify beforehand their rights and obligations, they only have to rely on a single state legal framework, right? And so keep in mind what is of the utmost interest for the parties is ultimately to have a clear answer about their rights and obligations. This is why they litigate in the first place. And so if they do not have to compare it to legal system that may produce conflicting answers. They just have a system, the one of the chosen form, with sometimes it's public policy, there are mandatory provisions, loi de police, it's choice of law rules. So this makes any prediction easier for them. And this, to the extent that that single legal system produces relatively clear answers as to rights and obligations of the parties, then there's no need to litigate. And this, I think, everybody is in everybody's interest. I think there was some of you who wanted to ask a question. Yes.
Yeah, my question is just if you take a look at jurisdictional agreements,
Right.
like for example at consumer contracts,
Right.
and if there's a clause about the jurisdiction, can these actually be quite unfair? I mean, we
Right.
also see this in arbitration where
Right.
like big companies have these clauses in
Right.
their contracts with consumers
Right.
concerning the jurisdiction.
Very good point. Which brings me to, so you have concerns, weaknesses, strong party may impose choice to weaker party. Case study 3, consumer case, Mr. Dupont is a French resident. He subscribed to an agreement, the terms and conditions, maybe general terms and conditions of that agreement, in the general terms and conditions may have been decided unilaterally by the company running the fitness center Silhouette. And we may imagine there's a choice of forum court in that contract. And we may imagine that the forum chosen in that contract, the forum indicated in that contract is a Swiss forum, Swiss court. Right now, under Lugano Convention and Brussels I Convention, they're almost identical, those two instruments. A choice of forum clause incorporating the contract would not be able to deprive Mr. Dupont of his right to sue Silhouette before the French courts of his domicile. So in other words, that choice of Swiss forum incorporated in that consumer contract would not be binding, even if Mr. Dupont specifically signed that choice of forum clause with a signature that indicates his willingness or his conscience, his awareness of that clause would not be binding on him. Solution number 2 would be to refuse to uphold abusive choice of forum. If you look at Article 5, Paragraph 2 of the Swiss Private International Law Act, you're not supposed to be familiar with that provision yet. But Article 5, Paragraph 2, this is a Swiss provision on choice of forum clause in international dealings. This Article 5, Paragraph 2 says a choice of forum, choice of foreign forum, choice of foreign court, a choice of non-Swiss court may not lead to abusively depriving one party from the benefit of a forum, a court in Switzerland. What about the fear that a Western company may have greater leverage in negotiating the terms and conditions of the contract, impose choice of Western court to Global South Company, and Western court may have a bias in favor of the Western company? What do you think of that fear? Right. So, the reason why I mention this is because, that there are obviously relatively few countries in Global South, although I do not like the expression, very few countries from Africa, from Asia, from Latin America that joined Hague Convention on private international law. If you look at 2005, Hague Convention on choice of forum, there is a choice of forum Hague Convention, 2005. We're going to study that convention. If you look at the contracting states, no Latin American country, no country from Africa, no country from Asia, almost no country from Asia, except Singapore. Why is that? I find it a pity, actually, but I think part of the reason why, and if you look at 2019, Hague Judgment Convention, mutual recognition of foreign judgments, here again, you don't find any Asian countries. And my idea is maybe, in case of choice of forum, Indian government may think this is an instrument for the parties to choose a forum in the UK, and then we have to recognize the judgment that this is once again, the British who have to dictate what we should do. And this is something that meet with some resistance. Jurisdiction agreement is less likely in tort acts or contractual liability. So if you think about case study number 1, defamation case study number 2, personal injury case, in those cases it's less likely, the parties are less likely to reach an agreement. Why? Because there's no prior contract between them. At no time they had to engage in negotiating the terms and conditions of their dealing. So who is bound by the jurisdiction agreement? Let's assume that in the employment contract between George Nilsson, Barbara Nilsson husband, and the employer of George Nilsson, Overseas Project Corporation, there's a choice of forum clause. Would that choice of forum clause be binding on Barbara Nilsson? Probably not. So sometimes when it comes to choice of forum clause, one of the questions or the challenges is exactly to identify what are the parties bound by that clause, and also what are the kind of disputes. If a choice of forum clause is incorporated in a contract, would then that choice of forum clause also apply to extra contractual disputes between the parties to a contract? We're going to study all this, so don't panic. I want to say a few words. Well, what's the time, by the way? What time is it?
3:08.
3:08. Okay, let's have a break then. Yes.
So trying to perform this class to take the exam in December.
Right. Where are you from?
Finland.
You're from Finland. Why would you like to take the exam in December?
In order to graduate on time, I need to start my master's thesis. And
Right.
my master's thesis, like the first, when the master's course starts,
Right.
they're mandatory attendance.
Right.
I'm not going to be applying for the master's course until November. That's when the application is. But in order to graduate, I need to be in one of those classes, and it's going to be in January.
Right. When exactly in January? Do you have the date? as
It
well?
depends on which master's
Right,
thesis
okay.
class, which subject I get
Okay.
into. So I don't
Right.
exactly know,
Right.
but it's very, very likely that
When would you know? When you be fixed in terms of the date?
the application is in November
Right,
and
right, right.
before
Okay,
Christmas.
okay, okay.
So,
So, write an email to us,
okay.
briefly explaining what you said.
Yeah.
If you have some evidence, then okay. If you manage to have a piece of paper confirming.
Yeah, I think I can ask the student exchange, but because they're not law specific faculty,
Right.
they don't know a lot about the law
Right.
faculty.
Okay. Anyway, so explain in a couple of lines, rather briefly,
Yeah.
why you think you qualify.
Okay.
Unfortunately, it's not the question. For me, it would be
Yeah.
better to have half students in December, half in January. It would be better for my personal organization. But
Yeah.
every time in the past we have been more liberal,
Yeah.
then the students' secretariat was angry with us,
Yeah.
and so we now are bound to really be rather strict in terms of who can do the examination. That's why, I would like to have an email that I can produce if ever, somebody is going to say, why did you allow and so on, that, safe ground,
Yeah.
that I can show them.
In December, I will have like an official, but because
Right.
the application is only in November. So.
Right. Okay, but write an email to us saying you might, even if the understanding is not absolutely sure.
I will get into some.
Right.
I just don't know which one.
Right.
So I don't know
Understand.
the timetable of it.
So I think it would be better for us to know now.
Yeah.
So write an email to us now saying, I'm going to confirm,
Yeah.
late November if this is really so.
Yeah, because I'm
Okay.
guaranteed a spot, but I don't know which one.
Right,
so
I
I don't
understand,
know which week it's going to start.
Right. Which university are you from? From Turku?
In Helsinki.
Right, Helsinki. Right. Good.
Turku doesn't have this.
Right, there's no, not the same master, no.
No, we are the same master, but they don't have.
They have a faculty of law, yes.
They do have a faculty of law. They
Right.
just don't. They can write their master's thesis on anything, and they
Right,
don't
right,
have
right.
to apply for a master's
Right, I understand.
thesis class.
Where would you like to write, in which area would you like to write your master's
I like
thesis on?
dispute resolution.
Right, I'm sorry, the
Dispute resolution.
dispute resolution, right? Civil between the private parties or, right?
Between private.
Right, good,
And
good.
that's what I do at work as well.
Good. And who teaches, private intellectual law, international litigation in your university?
Private international law is Liukonen or Clubdex.
Right, okay.
Clubdex.
Right.
It changes a
Right,
little
okay.
bit.
Good, anyway, it's good to have you here. We had a few Finnish students, always outstanding students. Right. Yes, we were happy to have a student from Northern Europe. Anyway, so write an email to us.
Write the email.
Thank you.
Yo no pude, yo no The other two Colombians, bro.
Los tres son el eje cafetero, Armenia, Perú y
Mi suegra en comentarios, una de como que era al libro, su bisabuelo, su valor de Holanda, me contaba que su padre, yo metió, bueno, algunos años en militares, después se paró un poco tanto, se hizo más. Mi mujer es por parte colombiana, creció 7 años en Colombia. No en Bogotá. Es colegio eléctrico. No tiene recuerdo, pero después de los años 90 bastante peligroso porque sus padres vivieron de trasladarse de Bogotá a Suiza. Entonces vivió los 3 primeros años en Suiza, después 7 años en Colombia. Pero ahora mi suegra y tenemos contactos muy estrechos colombianos, porque estudió ciencias políticas en la Universidad de los Andes, después trabajó a la misión permanente en Colombia unos años, después se casó con un suizo, tuvo que quitar el trabajo porque en aquella época, en los principios de los 80, no fue posible para los nacionales colombianos de seguir trabajando y se casaban con los suizos. Era bastante. ¿Ustedes son estudiantes de MITS probablemente?
No, de la maestría en Derecho, acá en la
Maestría, pero estudiaste en Colombia.
Colombia. Estudié Derecho en la Universidad Javeriana.
Javeriana.
Y
También.
No, es la Colombia.
Universidad de la Colombia, en Bogotá. Entonces, antes que esta salida, también estudias la maestría
En Derecho. Nos conocemos aquí de David.
Bueno, planteanos 1 o 2 años. Proyectos para el futuro profesional. Es un proyecto que gustaría hacer derechos humanos.
No, no me gustaría más trabajar por lo privado.
Asesorar experiencias internacionales. Hacer consultoría.
Esta es correa.
El tiempo que vives en Luisa desde cuántos años.
Hace 2 años.
hace 3 semanas.
Javeriana, sí, me parece que los primos tenía 2 primos que estudiaban en la Universidad Javeriana. Uno jugó al colegio San Carlos. Sí. Javeriana, que enseñó también cinema algo que tiene que ver con los Andes, algo de arte javeriano, uno de los primos. Muy bien.
Just for one semester or?
No, no, no. My course is here only, but I'm an old person, then I have to take my lecture. I can take one from the graduate or two not this semester, I'll take one next semester. They didn't have any other lecture.
So, arbitration agreement. This is not a class on arbitration. Let's say a few words about some advantages of arbitration over traditional litigation. For states A and state B, typically for India and Switzerland, with respect to case study number 5, to mutually exclude the jurisdiction of their mononational judicial courts and to allow the parties to submit the disputes to the jurisdiction of multinational arbitration court is also a way to coordinate the exercise of international jurisdiction. You know, not mine, not yours. Courts that may involve a individual, a national of both India and Switzerland. This is fair to the countries, not my court, not yours, which is the reason why the United Nations New York Convention of 1958 has reached a tremendous success in terms of number of contracting parties, 160 countries out of 193. This is 95% of world trade. And so it's interesting to reflect on the reasons behind this extraordinary success of this instrument. In 1998, Kofi Annan praised the New York Convention for establishing a setting which is favorable to cross-border trade, which is good for countries, for human societies, for communities politically organized as states. So this is fair to countries. I think this is also fair, which is just as important, if not more important, to individuals. This is a bilateral choice, and not just unilateral choice that may inspire one party to rush to the forum. Neutrality of arbitral forum, equal participation in nominating the members of the arbitral panel. This is something that I think may be consistent with fairness, that is ought to individual, preventing one party to choose forum to get a competitive advantage of unilateral choice to the detriment of the other, restraining forum shopping and curbing forum running, averting conflict of jurisdiction and parallel proceedings. Keep in mind, this is something that is not emphasized enough. When two parties, the Indian company and the Swiss company, agree to have any potential dispute submitted to an arbitral forum, let's try to penetrate once again to get into their psychology. But what I am really interested in is the psychology of human beings. Now, they don't hope that they will have to bring proceedings before an arbitration. That's not the first hope they have. So the first objective that is pursued by two parties when they negotiate an arbitration clause is to reduce the likelihood of a conflict between them, right? And I spoke to many chief executive officers, legal representatives. This is to encourage good faith, right? We don't want to have to litigate altogether. We want to reduce the likelihood of disputes between us, including disputes that we may then have to bring to the arbitration proceedings. And so this encourages good faith, this discourages forum running, this encourages efforts to find an amicable settlement, which is in the interests of both parties and both countries, right? Because taxpayers' money. And so this is something that is maybe appealing to them. I have a proof of what I'm saying. If you look at the modern, contemporary arbitration clause that tend to be incorporated in international contracts, in a significant number of cases, those arbitration clauses are as a matter of fact, mediation and arbitration clause. So you have the first part of the clause that is about mediation. And so this shows that the common will of the parties is to reduce the likelihood of one of the parties having to resort to arbitration. The parties are encouraged under a contractual obligation, mediation clause. That's a contractual obligation to engage in mediation. And sometimes the mediation clause say a party has to defer for 3 months, for example, filing a request, an application for arbitration, and has to undergo reasonable efforts to try to find an amicable settlement. Very interesting. Ability to designate arbitrators highly trained in the industry. That's also something that may be, credited, so something that arbitration clause may be credited for. There's a possibility through arbitration clause to avoid having to do with less well-functioning judicial systems. So now we've got to pay attention to the way, we have to be politically correct. A couple of 10 years ago or so, I had to deal with a litigation involving Monaco, Principality of Monaco. Right? There's not a lot of judges in Monaco. What I was told is there are just 3 notary publics. There are 20 judges or so. There's a significant number of judges coming from France, right? And what I was told is, they're corruptible, all of them. That was an exaggeration, obviously. But sometimes, let's face it, our country's judicial system is perfectible. Sometimes is less well-functioning, long proceedings. And so to be able to choose an arbitral forum is also a way for the parties to avoid having to cope with a less well-functioning judicial system. One proceeding instead of 2, 3, 4. If you think about case study number 5 once again, if there's no choice of forum, court, there's no choice of arbitration clause, then there's the risk of having a Swiss proceedings, having a competing Indian proceedings. That's first instance. We have to also keep in mind the appellate proceedings. So we may have a Swiss judgment only on jurisdiction saying, yes, we have jurisdiction. And that single judgment on jurisdiction may be appealed against by typically the Indian company. Then we may have a Swiss judgment on the merits that is still subject to appeal, right? So based on my experience, it happens many times. I wouldn't say the majority, obviously, but that things go on in the 2 countries, and they reach appellate. An appellate proceeding is a separate proceeding, right? With sometimes the same attorneys, sometimes different attorneys, and another proceeding. And so arbitration is generally shorter, although if you look at the statistics for a complex commercial arbitration case, 2 years, takes sometimes the arbitration 2 years, 2.5, right? Tends to be longer than 30 years ago, right, based on the statistics. But once the award is there, sometimes the parties in the contract, they said, okay, we engage, we undertake not to challenge the award, right? The award is going to be final and binding on us. Well, I'm not sure this clause is always valid, right? Right to review, is that a constitutional right? We may discuss. We may have different opinions. Some constitutions may have different opinions about this. But even if there's a set-aside proceedings, even if there's a possibility to have a arbitral award reviewed by a judicial court, setting aside proceeding before a court, this is just 2 instances, not 3, and not 3, 4 in different countries. Facilitated cross-border recognition and enforcement. This is a key point as well. Very, very important point. Precisely because we have the convention. New York Convention is primarily a convention, a mutual recognition of award. And so we have 160 states that decided together to engage, to undertake to recognize, mutually recognize the awards emanating from arbitrators sitting on their territory. There are a number of exceptions. There's an obligation to recognize and enforce subject to some exception. Right? And so one of the interests, the two parties to the Indian/Swiss agreement, case study number 5, to choose an arbitral forum over a judicial forum is, if they choose Swiss forum, India may have trouble recognizing the Swiss judgment. If they choose an arbitral forum, including arbitration sitting in Switzerland, India is bound to it. India accepted to bind itself to recognize and implement on the Indian territory an award emanating from a panel of 3 typically sitting in Geneva, typically involving a member appointed by the Indian company. We may assume that member is an Indian national, not necessarily, by the way, but that's a chance, right? And so there's the case number 5 is interesting because it shows, based on the relevant applicable provisions, that a country may have a greater trust in international awards emanating from international panel than mononational judgments emanating from state officials having 3 of them the nationality of that country. And once again, if you look at who is, on behalf of whom Swiss courts deliver justice, the Swiss Geneva judge is on behalf of République et Canton de Genève, right? And so that's not really an international judgment. It's a Swiss judgment delivered by Swiss nationals that are acting on behalf of not just the Swiss community, by the way, the Geneva community, right? And so an international award may be more interesting, more legitimate, precisely because even if the seat is geographically in Switzerland, when it comes to the philosophy, when it comes to the legitimation of the members of the panel, there has been an involvement, equal involvement of the Indian company and the Swiss company. So equality of arms, and this gives a greater comfort to India as a community, which is the reason why India has joined the system built through the New York Convention. I think some of you wanted to.
I was just disagreeing partially with the costs factor a little bit.
Right.
Because from what I think that again, like at least in an arbitration, so you are paying remuneration to the arbitrators, and if it's an institution, you are also paying a lot to the institution,
Right.
which is also, you can say, you can also rebut by saying that in the court also you are paying court fees. But again, I feel like even if you consider 2, 3, 4 different judicial procedures as well, even in arbitration per se, you have the arbitration only, where you have a lot of your briefing counsels as well as solicitors, and then you're not just focusing on the arbitration alone, you're also focusing on the interim provisional measures or judicial measures.
Same applies in the regional
Right.
in terms of equal.
Agreed. But then, when you're taking into account the arbitral procedure, then once you have an award, I think in Switzerland, you can only file a challenge before the Swiss Federal Court. So there is no further appeal after that because it's the topmost court, I feel.
You can have 3 degrees of jurisdiction.
Yeah.
So 3 degrees. Geneva lower court, Geneva appellate court, and then federal tribunal.
Right. So even in India, so I'm trying to understand. So in an arbitration per se, what I feel is that an arbitration generally is way more expensive compared to a normal judicial process. I understand the appeal procedure, but even I feel that a setting aside procedure, even if it's not technically an appeal, but again you have to necessarily brief counsels and solicitors to go forward with the next instance procedure. And then once you have a decision by the setting aside court, whether they have allowed or whether they have rejected the setting aside application, and then a lot of parties prefer an appeal before the next bench of the court, of the High Court for instance in India. And then once that court has also passed a decision, they will also try an SLP before the Supreme Court, a special leave petition. So again, the procedures, even if they are not technically appeal, but they are options which are given to the parties to go in to like basically recourse against the specific decisions. And again, it's a private procedure, so you have to necessarily pay the arbitrators, which are not necessarily paying to the judges per se. So,
Right, interesting. So, what I would say, the first thing I would say is, you're coming from India, I'm coming from Italy and Switzerland. I have experience in the costs of 3 simultaneous proceedings in 3 different locations, in inheritance matter, for example, with Swiss attorney being paid 500 to 800 francs an hour. So the alternative for me is proceedings in Switzerland, proceedings in France. This is what I have below my eyes, and a lot less court proceedings in India. That's number one. You know, the evidence-taking process, I argue can be more expensive when it's 2 or 3 courts of 2 or 3 countries that had to go through the evidence-taking. Ultimately, an expert that is an expertise costs the same whether it is produced before an arbitration, whether it is produced before a judge. The problem of having 2 judges, one in Switzerland, the other in Florida, for example, is that you have an expertise in Switzerland, and then you may have another expert that is appointed by the court in Florida. So, second, you mentioned judicial fees, right? Let me give you an example. I worked for a long months on inheritance dispute involving Switzerland and Italy. Proceedings in 3 locations: Turin, Italy; Geneva, Switzerland; and Bern, Switzerland. 3 different languages. We haven't talked about the translating costs, right? So 3 different languages, right? And the 3 kids, the deceased, filed a proceedings in Bern. You know what they had to pay for judicial fees? 800,000 francs. 800,000 francs. In Geneva, they would have been less. You may be surprised. What's about 800,000 francs? That's equivalent of the fees that would have to be paid if that case would have been arbitrated. Probably less, right? I have been a presiding arbitrator as well. So in that case, the fees were just in Bern. The judicial fees were incredibly high. And then I want to insist, each of the parties had to have attorneys in Bern. Each of the parties. Attorneys in Geneva. Attorneys in Turin. And would you think that in terms of strategy, the attorney of the same party in those 3 locations agree? No. Literally dozens of hours were spent for the attorneys to coordinate their work. So the expenditures were phenomenal. Phenomenal costs. Now, it's complicated to compare. We would need, that's an excellent subject for a PhD, by the way, right? We would need to have data. To have data, we would have to interview the parties. How much did you have to pay altogether, right? I worked also in child litigation, and you know, I'm trying to help for free a friend of mine who had already spent 100,000. Child litigation. The question is where the child should live. South Africa with his mom or Switzerland with his dad. Relatively easy to formulate. Proceedings in South Africa, proceedings in Switzerland, attorneys, appeal, counter-appeal, interim measure. They're waiting for 4 years now to have a decision. So something that is not emphasized enough is you're not likely to find any meaningful literature on this subject, is the costs, attorneys' fees, judicial fees of multi-state litigation before state courts, right? Something that, you know, I cannot say I have a lot of experience in arbitration. It's true that, but we don't have to confuse commercial arbitration with investment arbitration. That's different, right? So sometimes as a sole arbitration, but sole arbitrator, by the way, right? I served as an arbitrator once, and here is where I would like to, you know, say something that, you know, challenges of arbitration, concerns raised by arbitration. Stronger party may impose arbitration clause on weaker party, making it harder for it to mitigate their rights. Also, because of what you said, arbitrators, parties may have to pay them, yes. Although we may discuss about whether they're private, judges, you know, we may discuss at length, you know. But it is true that arbitrators are funded most of the time by the parties. In an interesting U.S. case, the business, it was a B2C case, the business was prepared to pay all arbitration costs, so the consumer didn't have to pay anything. Would we then have to, you know, have some reservations with respect to this? Too expensive for small claims litigation? I think there's a lot of truth in this statement. Unlikely in case of tort act or contractual liability, this is true because there's no prior relationship between the litigants. And so in case study 1, it is unlikely that Rachel Ehrenfeld and Bin Mahfouz managed to reach an arbitral agreement. Is arbitration suitable in cross-border child disputes? You know, I spent an enormous amount of time working on those endless, terrible cross-border child cases, and my conclusion is yes. It's not like a commercial arbitration. We need to work a new system, a novel system, but I think it would be better for the kids and for the parents. And I wrote extensively. You may, if you are interested, look at some of my publications on this. 2019 publication, 2022. If you're interested, you may look at the 2022 Yearbook of Private International Publication. I give a number of cases. Terrible. Terrible, right? If you're interested, have a look at this. 22 pages. I am going to share the link. And so after spending so much time thinking and working, yes, is arbitration not necessarily reproducing, you know, the features and hallmarks of commercial arbitration. For parties to agree on composition, arbitral tribunal may be long. True. Right. Sometimes one party is just not cooperating. One of the real problems to me is how to ensure party-appointed arbitrators are really neutral. That's a real problem. And that's a critical problem. You know, each of us comes from its own experience. I have little experience with commercial arbitration. I was once appointed presiding arbitrator in an international arbitration involving Austria and Italy, insurance matters. I think I told you about this already. The Austrian party appointed a German lawyer. The Italian party appointed an Italian professor of law, University of Rome. From the very beginning, they were just an extension of councils, right? To me, especially the Italian one. The Italian professor was so adamantly pro-Italian party that I was really disappointed. From the first hearing, my brother, who was also present, he's also a professor for civil procedure, both of us were disappointed by the attitude of the professor of law appointed as an arbitrator by the Italian party. But one could argue that the arbitration panel as a whole remained neutral because the presiding arbitrator being neutral, unless he himself is in a conflict of interest. Other problems. Some studies suggest arbitrators may be tempted to decide in favor of a party who may, in future arbitrations, appoint them. That's also a problem, right? This is a class, not a class of commercial arbitration. I know Thomas Schulz has a slightly different vision or significant different vision in mind, but I think there's some interesting features, and this is underscored by the success of New York Convention, 1958, 160 countries. I don't think the Hague Judgment Convention 2019 will ever reach such a success, which means that the governments and the parties seems to be more comfortable with international arbitration than with mononational. Another thing that I was interested to hear by a friend of mine, we wrote our PhD together, and then he moved on to serve as a counsel in a multinational company in the food industry, a conglomerate, especially in food. And so he said, based on our experience, we prefer arbitration when it comes to contracts whose value is until 10 millions. For contracts whose value is more, and the company had sometimes to enter into conflict for a supply of milk, for the supply of cacao, for the supply of wheat in excess of 50 millions. For those contracts, they rather not incorporate the arbitration clause. The value is so big that they don't want to lose the opportunity to have a state court review, including the Supreme Court review, including on the merits. That was the policy of that multinational company. I don't know whether this policy is widely shared. Litigation about validity, enforceability, scope of arbitration clause. That's a problem. Is arbitration clause binding on my insurer? West Anchor decision, West Anchor ruling. This is a ruling that you might find included in the list. I can't remember exactly. Arbitration rules of different countries may disagree on this point. Based on Italian law, the answer was no. The arbitration clause was not binding on the insurance company. Based on the English law, the answer was yes. Parallel, arbitral, and judicial proceedings with the possibility of conflict between judicial decision and arbitral decision. Let me give you an example. This is I'm not saying a common occurrence, thanks God, but this may happen. London Steamship Owners Mutual Insurance versus Spain. What happened was a oil tanker sunk off coast Spain and France. A significant amount of oil was spilled and damaged the coasts in Spain and in France. The Spanish authorities initiated, I think, civil proceedings, compensation against the insurance company of the company operating the vessel. The insurance company was the London Steamship Owner Mutual Insurance. Their headquarters was in London. Now, so there was a Spanish proceedings initiated before the Spanish court, civil court, and the defendant of the Spanish proceedings initiated arbitration proceedings before an arbitrator sitting in London. They were relying on an arbitration clause, and they were contending that the arbitration clause was binding on the Spanish party that happened to be the Spanish authorities, including, I think, the Spanish government. But I think the Spanish government was acting as a civil party may have done before a civil court in Spain. You may check. Bottom line, we have two proceedings, one judicial proceedings in Spain and a arbitral proceedings in the UK. The Spanish judge orders the English insurer to pay a significant amount of money. I don't know, 200 million. You may check. Significant amount of money. The English, so the panel of arbitrators sitting in London reach a different conclusion. No liability on the part of the insurance company. The English award is endorsed by the English courts. So we have a conflict between Spain and England. In England, we have an English award that is then confirmed by an English court. And so we have a conflict, ultimately we have a conflict between judgments, Spanish judgment, and the English judgment that incorporates the English award. The question that was referred to by ECJ, European Court of Justice, was, would under Brussels I regulation that was at that time applicable ratione temporis in England, despite Brexit, would Brussels I regulation that still applies in the UK apply to recognition in the UK of a judgment even when in the recognition country, meaning the UK, there exists already a judgment that endorses and incorporates a conflicting award. Right? That was the question. And what the ECJ said, Brussels I regulation still applies to the UK. This is not to say that Brussels I regulation in all situations obliges the UK to recognize and implement on the UK territory Spanish judgments. We're going to study recognition and enforcement in Brussels I. We're going to spend, I think, at least 2 hours, right? So I prefer not to, I'm not sure how the thing ended, by the way, but I think this shows that, conflict between proceedings precisely because one country says this is not arbitrable dispute, or one country says that arbitration clause is not binding on that party, may still arise. Now, how much time do I have left?
7 minutes.
It's 4:07. No, 7 minutes. Good. Right. I thought it was. I had just 1 minute, so that's good news for me, and maybe not so much for you. So now, step 3 is determining law applicable. Right. Remember what we said about case study number 1. U.S. law, UK law, they truly conflict in terms of rights and obligations. Remember what we said about case study number 2, law of China, the action is time barred. Law of Australia, Western Australia, Victoria, the action is not time barred. This individual right is still actionable. And so a little bit of terminology first. A conflict rule, conflict of law rule, choice of law rule, applicable law rule, governing law rule. These are interchangeable terms that refer to the rules. Can be in a treatise, can be in regulation, can be in domestic mononational legislation or private international law, designates in a cross-border relationship having connection with multiple states the law of the country concerned which is applicable. We cannot have law of all countries concerned simultaneously being applicable to the same question, to the same issues, obviously. Otherwise, we have a conflict of laws. And having a conflict of laws is like having no law at all. It's kind of anarchy. And so those rules, they do an important job of identifying, singling out the national law that applies to a multinational relationship and to a multinational dispute arising out of that relationship. Keep in mind, choice of law clause or governing law clause is a clause incorporated in an international contract setting out governing law of contract. So the term choice of law can be sometimes used to refer to the choice by the parties, individual parties, private parties, to the extent that the parties are left or permitted to choose the applicable law. And the term choice of law rule, that is prevalent in US terminology, refer to conflict rule, règles sur le droit applicable, right? So those rules, they essentially revolve around two principles. Number one is principe de proximité, principle of proximity, significant connection test, right? So what is the test, the connection that is most significant? Can be, if you think about case study number 2, Australia may think that the law that is applicable to this Chinese-Australian tort is the law of the place of tort, meaning Chinese law. And Australia may think that, and China may think that the law that is applicable to this tort is common domicile of the parties, you know. So common domicile or place of tort, sometimes place of contract, place of residence of the parties who had to effect the most significant performance of the contract. In family law, common domicile of the spouse, common domicile of nationality. In child-related litigation, habitual residence of the child defines what law applies. Case study number 4. So it's habitual residence of the child, who not only defines jurisdiction, but also defines, Article 15 of the Hague Convention on Protection of Children, the law that should apply. So what should be avoided is the conflict of choice of law rules. They create litigation unpredictability for the individuals involved as to their substantive rights and obligations. So we had to avoid China and Australia should strive to avoid having a conflict between their choice of law rules, a conflict between their rules and applicable law. And so for countries to work at a jurisdictional level only may not be enough to minimize conflicts and to combat forum shopping, right? And so even if Australia and China manages to work out rules on international jurisdiction that prevent conflict of overlapping jurisdiction in terms of their courts, still the idea of predictability, a legal certainty, a minimized conflicts, a minimized disagreements should cause them to try to minimize the conflict between their choice of law rules. A conflict of choice of law rules or a conflict of conflict rules may take two forms: positive conflicts of choice of law rules. If case study 2, China says Chinese law applies based on place of wrong, Australia says Australian law applies based on common domicile. That's a positive conflict of choice of law rules based on the domestically sourced conflict rules applicable in each of those countries. Those countries at any pre-litigation stage conclude that their own law is applicable, meaning that at any pre-litigation stage the two parties are really faced with a conflict of laws. China says Chinese law applies, Australia says Australian law applies. How do we go about resolving that conflict? This is where a race to the forum may actually help them, but we know the disadvantages. What may happen is a negative conflict of choice of law rule. If China says Australian law applies based on common domicile and Australia says Chinese law applies based on place of tort. This is exactly what happened in Nilsson case. If you want to have more details about how this case ended, this is a case I studied for long months. I wrote my Habilitationsschrift, my second PhD thesis, on precisely the situation. Negative conflict judge law rules. I spent 9 years of my life thinking about that situation. In one of the cases, I had to examine 150 cases in inheritance matter, in tort matter, predominantly. So these are, I think, the easiest. This is called Ramboy, meaning, you know, Australian designated Chinese law, and China referred back to Australian law. Renvoi is Ramboy. It means refer back, and this is a negative conflict of laws. How coordination of applicable law may be achieved? First idea, first solution, possible solution is for the countries concerned to reach a consensus on an international, supranational substantive law, sometimes called uniform law. Case study number 5. If this is an international sale of goods contract, then we have a Convention on International Sale of Goods, United Nations Convention on International Sale of Goods, that contain uniform legislation. That's not the Swiss Civil Code of Obligation, that's not Indian Sale of Goods Act. This is a common substantive law, legislation, that is enforced in almost 100 countries. This is enforced in China, enforced in the US, in Russia, not in India. Which brings me to wonder, what's wrong with India? Why India didn't join that instrument?
It's a very good instrument, the CISG, but I don't know.
Right. I inquired with my AI faithful friend. No, I try to find the answer. There may not be just one explanation to that. But if case study 5 would involve a Swiss company and a Chinese company or a company from Colombia, I think Colombia is part of that instrument. I think almost all Latin American countries. Then the beauty of this instrument is the parties would be subject to a Swiss/Colombian set of rules. This is an instrument that is part of Swiss legal system as much as it is part of the Colombian legal system. This is a supernatural, it's both Swiss and Colombian. It's called uniform. Uniform for the countries that joined that instrument. And so we don't have to select a single mononational law. We have, the parties have, a truly substantive international law that it's a instrument, 80 plus articles, I think, that directly provides for the rights and obligations of the parties. And this is a successful, apparently, according to some statistics, it governs 80% of the international trade. This is a figure I found in a Hague Academy course, monographic course devoted to this instrument. What this course was about is that even if this is a uniform law, some of its key provisions tend to be interpreted and construed, sometimes differently, by the domestic courts of different countries who joined this. That's a solution, and this solution exists for the most popular international contract in the history of humanity, the international sale of goods. And by the way, even if India is not part of this instrument, what the two parties, what the Swiss company and the Indian company can do is to write in the text of the contract, our rights and obligations will be governed by the CISG. I don't think that on the part of India would defer to a choice of Swiss law. So why India would have something to object to both parties choosing that international instrument? Yes.
I have a question
Yes,
in
go
that
ahead.
case. I have a question in that case of if they they didn't have this multilateral or bilateral treaty, and they were referred to, for example, the CISG, but they would forget to put in the clause what law the actual clause would be governed by, what would be the law in that case.
Okay, fair enough. Now, so first element of my answer is because not only India didn't join that instrument, but there's no multilateral treaty in place between the two countries concerned, Switzerland and India, about the proper law of contract, about the law that is applicable to international contracts. We are left with, and that's to me a problem. This is something that you have to change. 20 years from now, you've got 20 years to try to change it. This is inconsistent with, the common interest of Switzerland and India that 10 days ago they signed a trade agreement, right? And so, to answer to the question by our Finnish friend from Finland, I can provide an answer based on the mononational conflict rules of Switzerland. I can provide an answer based on the rules or principles that operates in India, but we're not guaranteed that the answer that is delivered by the Swiss legal system and the answer that is delivered by the Indian legal system is the same. And so the answer is provided in Switzerland is Article 117 of the Swiss Private International Law, who says essentially there's a presumption that the law having the closest connection with the contract is the one of the habitual residence of the supplier. Who is the supplier here? I'm going to assume the supplier is the Swiss company, because the Swiss company has to supply watches to the importer. And so, based on that principle that is encapsulated in Article 117, paragraph 2 of the Swiss Private International Law Act, it is presumed that the contract is governed by the Swiss law. This is a presumption, a strong presumption. It can be rebutted only if it is shown that the overall connection the contract has with India is overriding, is predominant. So we have principal closest connection test, and we have a presumption. It is presumed that the country having the closest connection with the contract is the country of habitual residence of the party who has to effect the characteristic performance of the contract, and in the supply contract, the party that has to effect the characteristic performance is the supplier. Right, that's the answer in Switzerland. With regard to the answer in India, we have our good-looking friends from India. I guess proper law of contract is a principle in English law. How do you go about identifying the proper law of contract, most significant relationship? The UK, England, that was party to Rome Convention on law applicable to contractual obligations, they applied essentially the same principle, right? And so, closer connection test with a presumption in favor of the law of habitual residence of the supplier. I don't know whether India follows, it's not the historical position of UK, it's the position that the UK decided to accept and to adhere to as a consequence of UK entering 1973 to the then European Economic Community. And so now I think even if UK exited the European Union, what I remember is
because they are used to applying, and UK courts are used to applying those European principles, they made a mononational legislation incorporating those principles into UK domestic legislation on conflict of laws. So I hope this answers the question.